years, he teaches media law, constitutional law, and business law. Dr. Iyer has been legal practice since 1981 and is, among other things, a trained mediator. Between 2008 to 2015, Dr. Iyer served as a law commissioner for Northern Ireland, a former Nobel Prize Fellow at Cambridge University. Dr. Iyer has lectured in a number of foreign universities, including Meiji University, Japan, University of Melbourne, Australia, Tsinghua University, China, Fordham University, USA, University of Malaya, International Islamic University of Malaysia, University of Bombay, and Shoko University, Taiwan, and continues to be a visiting professor in several institutions. As a part of World Bank project, he has designed a program on continuing legal education for the Kenyan bar. So today we are very lucky that we have Professor Iyer with us, and he is going to deliver session. There are two sessions are there. So over to Professor Iyer.
Thank you, Devang. And can I also extend a very warm welcome to the students who are attending this lecture, and hopefully also the lecture that will follow. I suspect you're probably going to be a bit exhausted by the time we finish, but I hope you'll still retain a degree of enthusiasm. I want to thank Nirma for inviting me to deliver these lectures, and I particularly want to thank Shreya Srivastava, Devang as well, Devang Chatterpati, and Madhuri Parekh for their numerous kindnesses. What I intend to do today is to talk for about 30 to 40 minutes on the topic of should freedom of expression include the right to offend. And then I will invite questions from the audience. I sincerely hope that you, the students, will feel free to ask questions, to bring in any experience that you might have, and to generally participate, because to me, that is the purpose of a session like this. So without further ado, let me plunge straight into the topic. And by way of introductory remarks, what I would say is that, as you may have noticed, there is a growing tendency not only for people to take offense too quickly, but also for calls to be made to suppress free speech, which they consider to be offensive. Now, I'm sure sitting in India, you would have a good sense of this, because there have been so many cases happening in recent months and even years when this tendency has come to the fore. I would consider this to be a very serious development, because in the long term, it is going to cause irreparable damage to freedom of expression. Now, one of the drivers of this tendency is the emergence of what is sometimes referred to as the Snowflake Generation. In other words, people who are just too sensitive to criticism. It was not so in the past. There used to be a lot of tolerance for criticism, but not anymore. People get offended too quickly, as I mentioned just a minute ago. And then, of course, there's also a breakdown on the consensus on what is offensive. Now, by and large, people have an idea of what constitutes offensive speech, but the consensus that existed before has, I think, begun to crumble. And therefore, you now have many people criticizing speech that in the past would not have been considered offensive. There's also a lot of loose talk about what kind of speech should legitimately call for legal sanctions. It is one thing to say, I don't like what you're saying. I find what you're saying offensive. Fair enough. But it's quite another to say, I don't like what you're saying, and therefore I want to shut you up. That, to my mind, is a dangerous trend. And one of the problems here is that in recent months and years, there seems to be a move from an objective standard to judge offensive speech to a very subjective standard. And I may have occasion to talk about this at greater length a little later. And as I said, all these things have grave implications for the future of free speech and for robust exchanges in, for example, academia and in society in general. So with those introductory remarks, I want to proceed and to talk a little bit about specific aspects of the topic on hand. Now, I suppose a good starting point would be to ask the question, what are the objectives of freedom of expression? In other words, why should we have freedom of expression? And I would say there are many, many objectives, but I'll just give you a few. So first of all, freedom of expression is necessary to facilitate the sort of debates that healthy societies need. Secondly, freedom of expression does have the objective of fostering critical thinking and also the objective to create an enlightened citizenry. This is very important for all societies. And don't forget that freedom of expression also is very important to hold governments to account. And that includes particularly the mission to expose corruption, which, as you know, is endemic in many societies. Yet another purpose of freedom of expression is to increase individual knowledge and also information about various issues that are relevant to a person's overall development. Freedom of expression serves another purpose, and that is to advance the boundaries of societal progress and innovation. Without freedom of expression, those things will not happen. It is possible to think of freedom of expression as also facilitating self-expression, which allows individuals to achieve their full potential as human beings. So there's a range of objectives that freedom of expression serves. And what I've given you so far is by no means a comprehensive list. I've just touched upon some of the key objectives. I hope you'll reflect on them and try to see how those objectives are thwarted by suppression of free speech on grounds that what someone says is offensive. Now, that begs the question, what should be the reasonable ambit of free speech? In other words, to what extent should free speech be allowed any space within society? And I would say that there should be maximum latitude for free expression. Remember, I'm not advocating free speech as an absolute right, because there is no right that is absolute. But I'm talking about a maximum latitude being given for expression. The law should not adopt a minimalist approach in this area. And quite frankly, there is a case to be made for the law to protect even heretics or dissenters or doubters against any punishments which may be created or devised to intimidate them or to silence them. That is not acceptable in a free society. And don't forget also that expression is not only free speech. It is also other forms such as art, sculpture, cartoons, plays, even music. So all those things also come within the ambit of free expression. Really, the most important test should be that expression can only be suppressed if it causes harm to other people. So do remember the importance of the harm principle. So basically what you're saying is that unless what you say causes harm, you should be allowed to say it. Now, the harm itself has to be clearly identifiable, and it has to be quite serious, not just trivial harm. Because in society, there is always the tendency for people to suffer slights. That should not be considered to be sufficient to ban freedom of expression. So the harm has to be quite serious. Ideally, the test should be whether the speech in question is such as to cause violence or is immediately likely to cause violence. So the dividing line, I would say, between acceptable speech and unacceptable speech will be the tendency to cause violence. Now, in the US, they have a very interesting and important test called the clear and present danger test. I would say that test is actually quite relevant when you're talking about the harm principle. Now, moving on, maybe it's a good idea to look at what amounts to causing offense. In simple terms, of course, causing offense means to cause anybody to feel hurt or angry or upset by something that another person says or does. That's a very simple definition of causing offense. But it's important to recognize that offense is very often contextual, which means that it depends on the context in which somebody says something as to whether that is genuinely offensive or not. So you can have people using cuss words between friends in everyday banter, but that is not something people take seriously. Most of the time, they would ignore such behavior. I'm not saying using cuss words is a good thing. Actually, I'm saying the opposite. But what I'm trying to say is simply because somebody uses cuss words in the course of light banter does not mean that they should be punished or their speech should be silenced. But of course, if the context changes and those same words are used in a completely different environment, then clearly different considerations apply. And of course, don't forget that sometimes offense is caused as a result of misunderstandings. People misunderstand each other when they should not. And then they take offense, which is just as unacceptable. A lot of the time, the reason why we take offense is that we have certain expectations of what someone will tell us, and those expectations are not met, or we have expectations of how someone will behave towards us. And when those expectations are not met, then we take offense. Again, this is not a reason why free speech should be curbed. You can, of course, point out that somebody's behavior is unacceptable, fair enough, but not to say that this calls for suppression of free speech. Now, you might then begin to wonder, does anyone have a right to be treated nicely at all times? Remember, I'm talking about a right, not an expectation. You may have an expectation to be treated nicely, but you have a legal right? I don't think so. In reality, there's always the possibility that people may not be nice to you at all times, in which case there are different responses, non-violent, civil responses, but not suppression of free speech. And sometimes offense is caused because of a clash of values. Now, we have to recognize that in this big world, people have different value systems. They may not always be of the same values as us. And in those circumstances, we have to give some leeway for that sort of difference. And so if, because of a different value system, someone says something to you in good faith, then I don't think we should take offense. And you know, at the end of the day, offense is largely in the eye of the beholder. And any attempt to make offensive speech unlawful is likely in the long run to place everybody's freedom of expression at the mercy of others. And that's not a good thing. So these are sort of things that I want you to reflect upon. Now, one other important question, particularly in the context of law, that arises is this: what are the standards that should be adopted to judge whether a reasonable level of offense has been caused? I've already spoken to you about the harm principle, but in addition to that, what test would you apply? And I would say there are two possibilities. One is an objective test, and the other is a subjective test. Now, in other words, should you, the person who is listening to speech that is objected to, be the sole judge of whether that speech is offensive, or should he judge it on the standard of an objective person? I would say that it is necessary to look at an objective standard, because that is a better basis to judge whether speech is offensive or not. Now, why do I say that? I say that because sometimes people tend to be hypersensitive. Now, if you're hypersensitive, then you will take offense very quickly. Whereas if you're reasonably laid back, you will take criticism or derogatory remarks in your stride. And that is why the law has a very important test called the reasonable person test. I'm sure you come across this phrase, the reasonable person, in the course of your study of law. And I would say that that test is just as valid in the case of free speech. Nowadays, of course, you have an additional factor which has created problems, and that is culture wars. As I'm sure you've read about and maybe even experienced, there is a lot of this going on. Culture wars do create huge problems. And if you want a very topical example of a cultural war, I would draw your attention to what is happening in Karnataka at the moment, you know, with the hijab situation. That is quite indicative of how sometimes you can have a tendency for cultures to clash. And the traditional English or British view used to be that the correct response to offensive words is either to ignore them or to answer them robustly with a rebuke. And that, I think, should be the standard that should be adopted. But nowadays, what's happening is that there's a view that is gaining ground, which says that only certain groups can talk about certain matters. An example is that only women can talk about abortion, or only Muslims can talk about certain practices in Islam. Likewise with Hindus as well. Now, the people who adhere to this viewpoint are of the view that if anyone else engages in such debates, then certain people and groups get offended. I put the question to you, should this tendency be encouraged or discouraged? The opposite view would be that everybody in society should be allowed to talk freely about all matters, freely but in a civilized way. This is very important. Which then brings me to another relevant issue, and that is the concept of protected space. So what it means is that, in simple terms, any comment that is made in private should never be criminalized, should not be made the subject of criminal sanctions. But of course, in the age of social media, not much is still private. A lot of things that are said are very public, but that is not an answer to suppress free speech, in my opinion. Of course, even on social media, you have to be civil in your interactions with others. Sometimes people get carried away. Because the problem is that if private comments become the subject of legal sanctions, then there will be a chilling effect on speech. And that is to be avoided in all free societies. One of the things that happens with people saying controversial things is that, in a way, it is like a safety valve. People are letting off steam, and that is not a bad thing in any society. And you may have heard about safe spaces, where certain viewpoints cannot be expressed. And that, to my mind, is quite worrying, because ultimately there should be no place where censorship is practiced on a disturbing scale. For example, in universities in many countries, there are certain things that are nowadays not allowed to be said. Now, to my mind, that is, in the long term, going to be quite problematic. Again, I hope that we'll have a discussion about some of these things. Now, I've told you a lot about the need for the law not to interfere with free speech, but I want to now look at the other side of the coin and tell you emphatically that I'm not in favor of offensive speech. So if I've said anything so far that may have made you think that I'm in favor of speech that is offensive, then I have to tell you very clearly I'm not. And how do I square the circle? I square the circle through the use of ethics or self-discipline. So what I'm saying is that everyone should have the right to say offensive things, but they need not make use of that right. So it's a bit like saying, I don't want a drink, by which I mean an alcoholic drink, but I cannot do without the right to drink. I hope you understood the nuance of what I'm trying to say. So I should have the right to say things that others may find offensive, but I should not, as far as possible, say offensive things. So when you talk about ethics or self-discipline, you're talking about obedience to the unenforceable. And really, you're also talking about good manners, which is important for anybody. Good manners, prudence, or discernment, or whatever you call it. And this includes courtesy and mutual respect for others. Very, very important. Courtesy for others and mutual respect. And so you can actually control the spread of offensive speech in that way, but not through criminalizing speech or suppressing speech. I do believe that there is sometimes value in naming and shaming people who deliberately, unwarrantedly, and gratuitously engage in offensive speech. So you do find, for example, a lot of comedians use cuss words all the time. They don't need to. Now, that is something which should be criticized, but they should be allowed to say what they're saying as long as it doesn't cause harm to anybody. But they can also be named and shamed so that they will themselves realize that what they're doing is not acceptable. And I do personally believe that the power of robust debate in society to drive out bad ideas cannot be underestimated. In other words, that, you know, if you have robust debate, then good ideas will drive out bad ideas. Now, I realize I don't have too much time left, but in the time remaining, I just want to talk a little bit about the Indian situation, because I'm obviously addressing an Indian audience. And the first thing I will say, I don't know if you agree with me, is that there is nowadays massive evidence of hypersensitivity and over-the-top reaction when it comes to speech that is considered controversial in any way. I've sometimes heard the phrase used in India by certain people that Indians have made being offended a national pastime. There was actually an article I read some days or weeks ago, which was titled, in relation to India, "The Republic of Hurt Sentiments." Just imagine what a serious indictment that is. And of course, a major impulse for such cases of overreaction is to seek cheap publicity that cannot be ruled out. Sometimes it is also virtue signaling by the politically correct brigade. And if you want to discuss that, perhaps you could bring it up in the Q&A session. Now, one of the reasons why this tendency has unfortunately been allowed to flourish is because of a certain laxity on the part of the Indian judiciary in clamping down on frivolous cases. A lot of the time now, I notice that all that is needed for some severe action being taken under the law is for someone's sentiments being hurt. You'll come across that phrase a lot when you read newspapers in India, sentiments being hurt. And of course, unfortunately, the media are also to blame when it comes to giving space to attention seekers. So you can't you can't let the media go scot-free in this respect. And I'm sure you know of many, many instances, much more than I do, of unjustified offense being taken in India. You may remember, for example, I'll just give you at random what I can remember. You may remember that there was a controversy, I can't remember when, but a few years ago, of a controversy involving the cricketer Dhoni, apparently because he had appeared on a magazine cover, or rather his face had appeared on a magazine cover as Lord Vishnu. Now, a lot of people took very deep offense, and all kinds of action was being sought against Mahendra Dhoni. Then, of course, there was also the case where the makers of the television serial Tandav were hauled up before a court, again, for hurting religious sentiments. I think what they were trying to say was the people who were criticizing were saying that Hindu gods were shown in an uncharitable way in that TV serial. When it comes to books, there was the case of Wendy Doniger's book, The Hindus, an Alternative History, which was to be published by Penguin, but Penguin then withdrew the book after a lot of protests. This then reminds me of the many cases that were filed against the artist M.F. Hussain for hurting the sentiments of Hindus because he painted Hindu gods in what the critics called a derogatory way. Amazon was criticized, and I don't know whether a case was filed against it, but it was criticized for selling on its US site rugs and toilet seats, toilet seat covers, which showed images of Hindu gods. So there's no dearth of examples of cases where people have taken offense for something or the other. In relation to advertisements as well, there's quite a lot. And actually, there was a report quite recently, I think it was last month, by the Advertising Standards Council of India, ASCI, which was probably called what India takes offense to. So you may want to look that up, and it'll be something which will also open your eyes to the extent of sensitivity there is in this matter. So I've spoken enough. Just to wrap up, can anything be done to improve the situation? I would say that the solutions would consist of a multi-pronged approach, and there will also need to be very decisive action taken on various fronts. The first thing is, when you're talking about the law, there is probably a case to be made for some legislative amendments. So I would say that some of the sections in the Indian Penal Code would need tightening. They are at the moment worded a bit too loosely, and so legislative changes are important, but they're not enough. Just as important would be mass education about these matters. And I'm glad that Nirma University is facilitating a debate through discussions and lectures like this. So mass education is extremely important. I would say as well that there is a need for very extensive training for judges, because the judges need to change their mindsets. And as well, you can think about the media. Journalists need to be reoriented to some of these realities. Confidence building is another very important factor in all this. In other words, you have to bring about greater understanding, greater confidence between various villages, castes, linguistic, and other communities, so that people don't take offense as readily as they seem to be doing now. And even within each community, there should be greater self-confidence being inculcated. And this is again part of what we may call mass education. Of course, all these things are solutions that require a long time to bear fruit. So it has to be a combination of both short-term, for example, legislative changes, and long-term strategies. There is no magic bullet to tackle this very worrying problem. But unless you make a start, you're not going to at all improve the situation on the ground. I think I'll stop there and take some questions. Thank you.
Thank you, sir. Now session is open for question and answer. You may give your question on chat box. Sir, as you have say that we have to tighten the legislation. So
Yeah.
the first question I would like to ask that I can recall that Shreya Shingal versus Union of India case.
Yep.
And section 66A of the Information Technology Act 2000 was abolished by
Yep.
the Honorable Supreme Court. They say it is unconstitutional vis-a-vis Article 19. So now I'm feeling like that okay, you are on the other one side saying that we have to tighten the legislation, and I'm feeling vacuum after that the Shreya Shingal case, that if there is some incidents occur where
Yep.
people express in the platforms, social media or other platforms, where nowadays we are flourishing and our day-to-day life activities are means associated with social media, and due to social media we become, I can say like that, we become more hyper or aggressive and we start to express lots of things. So what's your view on that?
Well, you raised an important point. There are two ways in which you can try to deal with defective laws. One would be to have legislative change. In other words, Parliament decides to bring about amendments to the law. So that's one way of doing it. The other way is what you've just pointed out, and that is for the courts to strike down law that is either overbroad or patently unconstitutional. So judges do have many techniques, including the technique of reading down a statute. So I'm not at all against that route, but all I'll say is you may not always get wise, sensitive judges. Now, in that particular case that you referred to, Justice Rohinton Nariman was a good example of a wise and sensitive judge, and he could make out very quickly that that particular section of the Information Technology Act was so loosely worded that there was massive potential for abuse. And so what he did was he used the power that he has as a judge in a country like India to strike down the law. Now, India in that sense is lucky because judges do have the power to strike down laws on the grounds of unconstitutionality. That can't happen in the UK. In Britain, a judge cannot ever strike down a law passed by Parliament. So it is possible for judges to strike down unconstitutional laws or laws that are extravagantly worded. But my reason for suggesting legislative amendment is that you cannot be sure whether, first of all, whether a case will go to court. Because remember, a judge can only strike down a law if there is a case in front of him. He just can't do it unilaterally. And secondly, you cannot be sure that you're going to get a wise, sensitive judge at all times. And to be very frank, I am probably going to say something controversial. Looking at the quality of judges in India today, I'm not very confident that you will always get judges of the caliber of Rohinton Nariman. And in those circumstances, it is much better that you have a long-term solution in terms of legislative changes rather than rely on the tender mercies of judicial action.
Yes, sir. Sir, I have a question from Rohan Patel,
Yep.
his student. What are the international landmark judgment in respect of the free speech which could be followed?
That is a question which is impossible to answer in the course of a session like this, but I'll give you some pointers. So if you look at um, the decisions of the European Court of Human Rights, which is based in Strasbourg, you'll find that there are hundreds of cases from various countries. And these cases span a huge range of subject areas. So you can certainly learn a lot from them. And a lot of them actually do take a really sort of moderate approach when it comes to many of these controversial issues. But don't forget that international law is not as effective in practice as domestic law, because it is possible for a legislator or the executive or even the judiciary to say that international law is not binding. And that is true. Of course, in a very limited sense, international law is binding on those countries which have specifically agreed for international law to bind them. So an example would be all those countries which are parties to the European Convention on Human Rights. Now, the governments of those countries have taken, have agreed to abide by the decisions of the Strasbourg Court. But what if a decision is not abided by? There's not much that can be done. Of course, the ultimate sanction is for the country to be expelled from the Council of Europe, but that doesn't really help the situation much. So the point I would make is that international law is of very limited use. It is helpful in persuasive ways, but it is not going to be binding in any way.
Thank you, sir. Sir, next question is from student that Tharun Pranav, but that question is related to sir hate speech. That why should decide what is hate speech in, means who should decide what is hate speech on online global community? So is there any medium to decide?
Yeah. Can I defer an answer to that question to the next session, where I'm going to specifically address hate speech? No problem. And if I forget, just remind me.
Sure. I will remind.
Okay.
I will remind
you,
sir.
All right.
Sir, I'm not able to find any questions.
Any more questions? Right.
No, from
okay.
Students.
I can see some questions in the chat box here.
Yes.
But okay, there's one at the top which says there's been underreporting of hate speech in India. That's as a comment. It's not a question. And then mostly comedians have a disclaimer before cussing. That is neither here nor there. Why should they use cuss words at all? Why can't they make their point without being so crude or vulgar? And then there's something I can't understand, this clothes with Indian flags. I presume what is being spoken about is it okay for people to wear clothes with Indian flags? I can't see what the legal issue there is, or even a societal issue. Conflict-sensitive reporting will help dispel the us against them fallacy. Up to a point, yes. Journalists should be taught conflict-sensitive reporting skills. I agree with that. Multicultural awareness campaigns should emphasize knowledge about and respect for the diversity of cultures and traditions. Yep, undoubtedly. That's part of what I was talking about when I said that one of the solutions is mass education. Who should decide what is hate speech? I mean, that's what you just referred to. So that I'll talk about that in my next session.
Yes.
And then it makes the comedian funny, and the cussing only makes the audience laugh. And the comedians are forced to do it as their lives depend on the profession. I'm not entirely convinced about that, because it is possible for a comedian to be funny without using cuss words. And in fact, in some respects, they can be funnier than by using cuss words. I'm not saying, therefore, that they should not be allowed to use cuss words. As I said before, it is a question of self-discipline. So what I would say is allow somebody who wants to use cuss words to do so. Then ultimately, it is for the audience to send a signal. For example, if a majority of people believe that a particular comedian is just being vulgar for the sake of being vulgar, they will simply boycott his shows. That is a better way than to say we will not allow this man to talk. So ultimately, audiences do have a lot of control. So for example, if you don't like a particular politician's speech, which is always full of offensive material, then you should ignore, or you should boycott such a politician. Boycotting is different from canceling. You can't insist on somebody's free speech being suppressed or cancelled. I'm completely against the cancel culture, but I do believe that people have the right and the responsibility to decide for themselves about whether they want to encourage someone by attending their meetings or lectures or whatever.
Sir, may I ask question?
Yeah.
Sir,
Sure.
in India, we consider that media is a fourth pillar of democracy. And the freedom of expression, definitely, sometimes they protect it also, and they sometimes express in such a manner that it looks like that they are crossing some limits.
Yeah.
So what's your suggestion and opinion on it?
Okay, you've raised a question which has huge implications, and I spend a lot of my time doing media law training, not just media law training, but also media ethics training. Because remember, both are important. It's not enough for journalists just to know the law. They also have to behave ethically. So a lot of my time is spent doing exactly that. And there is only so much you can do by way of training a journalist in the law or ethics. Ultimately, to a large extent, there has to be self-awareness and a willingness to do certain things on their own. So they have to heed their conscience. But in India, there is a problem. There's a huge problem. Firstly, there is a problem of lack of knowledge and technical skills. So if you read any newspaper, watch any TV program, it is very rarely that you'll find journalists speak properly, by which I mean in full sentences, grammatically, without making errors. That is one aspect of it. It is important because if you're going to be a reporter, the least you can do is make sure that you speak in a way that informs the audience. If you yourself don't know how to construct a sentence, then you're misleading the audience. Very, very important. I don't think people have understood the vitality of this particular problem. The other issue is journalists don't do their homework properly. So when they are reporting on something, they just seem to do it in a very lazy way, accept at face value what someone else tells them without cross-checking, or simply accept a press release or any other document that is given to them, which is also a major cause for concern. And thirdly, there is the issue of ethics. There are many journalists, I'm sorry to say, who are least bothered about ethics. So they would actually be quite willing to do what someone pays them to do. And that is why I'm sure you have come across this phrase, paid news in India. It's a major, major problem. And it is only the tip of the iceberg. Quite frankly, the situation has become, I think, unmanageable. And so one needs to be very aware of the deficiencies of the media. All these are problems which have so many angles to them. It's almost impossible to think of a solution that would address all of them in one go. And in any case, it's going to take a long time because, for example, how do you bring up levels of knowledge and skill among journalists. You can't do it immediately. It will take a generation or 2 generations. Actually, Indian journalism used to be very good 2 generations ago. So for the last 2 generations, things have deteriorated very badly and it's going downhill. So to come back to the original state, you will have to probably wait for a generation or 2. But who knows? I mean, I live in hope, and I do believe that it is possible to salvage something even in these dire circumstances.
Okay. So there is no more question, but I'm eager to ask last question.
Sure.
Sir, right now OTT platforms are there.
Yeah.
And there are lots of things are put on the OTT platforms. So they say that this means they are expressing the art and that, and there are lots of things are put and expressions and the name of freedom of expression. So is it necessary to control it or not?
Well, of course, it is necessary if what is being put out is against the law. So the fundamental point I would make is that all the laws that apply to traditional media, what is sometimes referred to as offline media, would apply to online media as well. Don't forget that, because if somebody says something defamatory, whether they say it in a newspaper or whether they say it on an OTT platform, the law is exactly the same and the law should be applied exactly the same. I'm talking substantive law. I know that there are problems when it comes to procedural law, because what happens if somebody says offensive things about someone in India sitting in Kazakhstan? Now, how do you deal with that person? That is a separate issue. That has to do with procedure and enforcement. But substantive law is still the same as for traditional media. So if you're thinking of bringing about changes, there will be 2 sides to be addressed. One is the substantive law robust enough to address these problems? And the second is, how do you deal with the new challenges that are brought in by online media? Now, the second part is more difficult to answer because technology keeps changing so rapidly, and the law is usually 1 step behind technology. So it's not easy. Okay.
Yes, thank you, sir. So now we have a next session. So what should we do?
We can actually take a break now between the 2 sessions.
Okay.
I would say 5 minutes, because actually we are running 5 minutes early, and then start at whatever time it is, 5:30 your time or 6 o'clock. I
It
don't
is
know what.
4:30 our time.
4:30. Yeah. Okay. So let's rejoin in 5 minutes time. Okay.
Yes.
Sure.
So I request all the students not to leave the meeting, that we will resume again after 5 minutes.
And Devang, should I leave or not leave? I'll come back. Otherwise, I can do one thing. I can just switch off my video.
Yes, sir.
And,
yes, sir.
I will continue to be on this meeting. Okay.
Yes, sir. Yes, sir. Thank you, sir. Start. So now we have a next session, that is, can hate speech ever be regulated, and if so, how? So over to Professor Iyer.
Okay, just give me a minute.
Yes.
Can you see me? Can you hear me now?
Yes, sir. Very well. You can start.
Okay, thank you. I just wanted to have a sip of water, so I'm fine now. Okay, so all right, if everybody is in, then let's begin our next topic, and it has to do squarely with hate speech. Now, the one thing that you may have already gathered is that there is some overlap between our first session and this session, because in that session, I spoke about offensive speech, and quite clearly, hate speech is offensive. But there are differences because it is possible for speech to be offensive, but not necessarily hate speech. So keep that distinction in mind. I'll try to the extent possible to address the concept of hate speech alone in this session, but it is important to recognize the overlaps. And quite clearly, there are two big interests to be balanced when you're talking about hate speech. First of all, there are free speech interests, that is, interests which go to the importance of freedom of expression. And on the other side, you have the equally relevant interest in ensuring that people are not subjected gratuitously to racial or religious or linguistic or casteist or other similar attacks. So those considerations really, as in many other areas of freedom of expression, involve a balancing act. Nobody can deny the importance of free and frank public discourse in any liberal democracy. I would actually say it's better to use the phrase free society rather than democracy, because there are different connotations of democracy. Sometimes you can have just formal democracy without having the attributes of a free society. But when you're talking about hate speech, there are particular risks in fragile, deeply divided societies, which means that if you have a country that is, for example, multilingual or multi-religious or having many castes, then the importance of regulating speech would be that much higher than in a homogeneous society. But even in homogeneous societies, sometimes there's a need for regulation in this area during periods of crisis. And of course, one of the considerations that apply is the effect of hate speech on minorities. And that is what has impelled a lot of legislation and other measures. Now, I want to go back to a point that I made in my first lecture, and that is to note the distinction between incitement to violence and merely causing offense or discomfort or embarrassment. I'm not trying to belittle the effect of discomfort or embarrassment on the person who is targeted. I'm simply saying that you still need to keep those things separate from speech that is likely to incite violence. And of course, in this particular area, the dilemmas faced by journalists are even bigger, because how will a journalist report a hate-filled speech made by a politician? And as you know, there have been many cases like that in contemporary India. Should the journalists actually reproduce those hate-filled passages in his or her reports, for example, in a newspaper or television program, or should they sanitize what they hear? It's a big dilemma. There's always the risk of overreaction to hate speech or overregulation of hate speech. Now, when there is overreaction, there's a danger that hate speech will go underground, which will only make it worse for society. So keep all those things in mind. Those are just by way of introductory remarks. Now, what is the basis for hate speech laws or laws targeting hate speech or curbing, intended to curb hate speech? First of all, there is the need to prevent disorder in society. There is an even bigger need to avoid any incitement to violence. Equally importantly, there is a need to avoid any damage to an individual's dignity. That's important as well when you talk about hate speech. In a larger context, you can talk about prevention of hostile or unjustified discrimination against particular groups. Again, equally on a broader level, you can talk about promoting social harmony. That's one of the functions of some of these laws. Now, some people have said that hate speech laws or anti-hate speech laws are also put in place to increase freedom to live without harassment or intimidation. That is a little more debatable. And of course, the subject matter of such laws varies from country to country. So in some countries, the problem is race. In some other countries, the problem is religion. In a third country, the problem may be linguistic groups. And in India, of course, you have in addition the problem of caste. That is why you have laws which make it an offense for people to make hate speeches based on caste. And to a large extent, these things are determined by historical factors and current tensions. Whatever is put in place will have to be done with a lot of care and thought. Is it possible for the law alone to curb or prevent hate speech? My answer is not generally. You do need law, but the law is not enough. And you normally would use a combination of strategies, which would be roughly the same as I indicated previously in relation to offensive speech. And that is, you have law, but you also have education, persuasion, and self-regulation. And part of self-regulation would also be what is called soft law. In the context of hate speech as well, the importance of naming and shaming cannot be underestimated. What do I mean by this? I mean that if somebody makes it a point to gratuitously indulge in hate speech, then that person should be named and shamed so that they will stop doing what they're doing. Now, it all depends on whether they have a thick skin or not, but it works in many situations. It's very difficult to be highly prescriptive in this particular area. So all you can do is adopt a broad brush approach unless you know very specifically the facts of each case. Now, in most societies that value freedom, the law only penalizes such words as have a tendency to cause violence or imminent violence. So I'm thinking particularly about the standard used in the US, which is quite a good standard in some respects. And in America, they have the concept of fighting words. So that's a test which is often used. And if you look at some of the cases that have arisen in America, then you get a very good sense of how the judiciary handles the situation. So cases like, for example, Chaplinsky and Chaplinsky versus New Hampshire is just one example. In very general terms, what are the principles that can be, not just can, but should be used in relation to hate speech laws? First of all, the restrictions that such laws impose on free speech must be construed strictly. You cannot adopt a loose construction in those matters. Also, any sanctions that are prescribed in the law, for example, imprisonment or fines, should be applied sparingly. In other words, the law enforcement authorities should not be gung-ho when it comes to applying sanctions. Underlying all this is the need for enough consideration being given to free speech. In other words, maximum latitude to be given to freedom of expression. There is a need to avoid self-censorship. Very, very important, because if the laws are seen to be too harsh, then people become hesitant to express themselves, and then that leads to self-censorship. And of course, it goes without saying that there should be strong judicial protections. Without that, nothing, no law is going to be effective. Now, very quickly, I want to talk about one or two international standards in the area of hate speech. So if you look at the ICCPR, the International Covenant on Civil and Political Rights, then you will come across Article 20 of that document, which calls for a prohibition of the advocacy of national, racial, or religious hatred, where it would lead to discrimination, hostility, or violence. So that's a kind of standard used in the ICCPR. And then, of course, Article 4 of the International Covenant on Elimination of Racial Discrimination, CERD, requires governments to make punishable any dissemination of ideas which are based on racial superiority. And there is a fair bit of jurisprudence, if you can call it that, which has come out of both the ICCPR and CERD. Now, let me give you an example of hate speech laws. So in the UK, for instance, we have something called the Public Order Act, and that criminalizes any threatening, abusive, or insulting speech which is aimed at or is likely to cause racial, religious, etc. hatred. Fairly straightforward and simple formulation, but of course it has to be applied carefully. Another formulation which comes from Canada would be something like it is an offense to incite hatred against any identifiable group, where such incitement is likely to lead to what the Canadian law calls a breach of the peace. So there are different ways in which legislation addresses this issue. Now, I would say that no matter how carefully the law is worded, there are certain factors that need to be taken into account when applying the law. So, for example, if you're talking about, just for the sake of simplicity, an article in a newspaper which is alleged to be hateful, which amounts to hate speech, then of course one of the questions that needs to be asked is, for what class of readers was that speech or that article primarily intended? you could also think about a few other factors that come into the picture. So what is the state of relations that prevailed or was prevailing between different classes or communities concerned when the article was published, at the time of publication of the article? And a further question might be, were the words complained of in the article bona fide expressions of criticism, or were they not? Equally importantly, were the words couched in dignified, temperate, restrained language? Very important. Or was the language used extravagant? Another question that can be asked is, was the article based on historical research? And was it intended for serious study? Because that happens sometimes in publications that are not newspapers, but journals and other similar vehicles. And of course, you can also ask whether the words in question were aimed at a well-defined and readily ascertainable group of people. In other words, not a sort of scattergun approach. The standards that judges should use when judging these matters is that the effect of the words should be judged from the standards of reasonable people. Reasonable, strong-minded, firm, and courageous people. I go back to what I said in my first lecture, which was about the reasonable person standard. So you should not judge the effect on the basis of weak, vacillating minds, but really on the basis of strong-willed, strong-minded, reasonable, courageous people. And there must also be a proximate link between the speech and public disorder, or the public disorder that you're fearing. So there are so many matters that need to be taken into account when judging these things. Now, I told you in my last lecture that some of the Indian laws are rather loosely worded. So let me just very quickly mention a few of the laws. I'm not going to go into detail because you know those laws as well as I do, probably better than I do. So let me just give you an idea of the kind of laws that apply when you're talking about hate speech. First of all, the Indian Penal Code, you have section 153A, which is used a lot, where the section talks about any words, words or other visible representations which have the effect of causing disharmony or feelings of enmity, hatred or ill will towards different religious, racial, language, or regional groups or castes or communities. Now, of course, it has to be understood that the essence of this offense is malicious intention. And that can be inferred from the offending words themselves or from the context. You also have section 153B of the IPC, which it's actually quite a long section, which again makes it an offense to publish imputations or assertions, which essentially says certain classes of people cannot bear true allegiance to the Constitution of India or cannot be loyal citizens of India, etc., etc. I'm just paraphrasing that very long section. Yet another section that's been used in India is 295A of the IPC, which makes it an offense to commit deliberate or malicious acts which are intended to outrage the religious feelings of any class of people, essentially, causing insult to the religion or religious beliefs of such people. Now, one of the things to remember about this section is that any rational criticism that is made in good faith, remember that is important, even if it tends to hurt the feelings of followers of that particular religion, will not be deemed to meet the threshold of Section 295A, only if the speech amounts to an aggravated form of insult and has a tendency to cause a breach of the peace will it amount to a punishable offense. So, one needs to be very, very careful when one applies a section like this. There may be a reason why legislative change is desirable, but even as it stands, a sensible judge will be able to use the section without causing too much harm to freedom of expression. So really, in a sense, you also have to take into account both the matter of the discourse and the manner of the discourse in order to arrive at whether an offense has been caused. Now, just by way of an indicative case, I want to throw my mind back to something that happened more than 10 years ago in relation to the Statesman newspaper, which, as you know, is the oldest newspaper in India, oldest English language newspaper in India. Now, what happened there was that some hotheads became very agitated over an article that was published in the Statesman, which was headlined, why should I respect oppressive religions? This was just a reproduction of an article which had appeared in a newspaper published in London. And yet, as I said, these hotheads organized street protests and a blockade of the Statesman's headquarters in Calcutta. So there was a law and order problem. And unfortunately, a case, a prosecution under Section 295A was launched against the editor of the Statesman and its publisher. Now, clearly, this cannot be right. Why? Because the newspaper did nothing by way of inciting violence. On the contrary, the subject matter of the article was one of public interest, and therefore people should have debated it. If you don't agree with the viewpoint expressed in the article, by all means write another article challenging that viewpoint. But it is not a good idea to threaten violence. There's one other section in the Indian Penal Code, which is 298. And this is used normally to deal with cases where people say or do something with a deliberate intention of wounding the religious feelings of another person, or they make sounds or gestures which may have that effect. Again, it has to be used sensibly and not in a scattergun way. One more section that I can think of is 505 of the Penal Code, which talks about making it an offense where somebody circulates any statement or report containing a rumor, which has the effect of promoting feelings of enmity, hatred, or ill will between different religious, racial, linguistic, etc. groups. Now, I don't have the time to go deep into this, but I would draw your attention to a case that happened many, many years ago, almost 30 years ago, involving a man called P.S. Pasricha. So if you have the interest, then go to Google and search for the case of P.S. Pasricha and the Sunday Observer newspaper in Bombay. Ultimately, of course, nothing came out of the prosecution, but it is something which caused a lot of concern. There's one other Indian law which has been used sometimes in the context of hate speech, and that is not in the Penal Code, but in the Code of Criminal Procedure, Section 95. So what it does is it allows the government to forfeit copies of newspapers, books, other publications that contain matter which is likely to promote enmity between different racial, religious, etc. groups. The language used is quite similar to what you found in other sections of the Penal Code. And this, incidentally, was the section used first to ban the Satanic Verses, the book by Salman Rushdie. And of course, you have the Cinematograph Act in India, which allows for censorship of movies which contain visuals or words that are contemptuous of racial, religious, or other groups. Now, I think this law also is extremely loosely worded. As I said, I've only given you a very small sample of laws. There are other laws as well. For example, the Cable TV Networks Regulation Act, and then crucially also the Information Technology Act, to which Devang made reference earlier. And I briefly hinted at something else, which is the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act of 1989. So again, there is a fair bit of laws in addition to the Penal Code. Now, again, I'm conscious of time, so maybe what I should do is, okay, at this stage, maybe I'll give you an example of what in other countries has been held to be hate speech, and or held to be unacceptable hate speech. So there was a case in Australia which involved a radio show. And, you know, in Western countries, radio shows have hosts, radio jockeys, who are quite bullish, who are quite robust in the way they express their views. So in this particular case, the radio jockey, the anchor of the program, was dealing with a caller, just a listener to the radio program, and the caller had said something which this anchor wanted to challenge, and he said something like, you know, I'll tell you what, and the name of the caller was, I think, Stuart. I'll tell you what, Stuart, you are so typical of your race. You're belligerent, you're a bully, you are a loudmouth, etc., etc. Now, many of the things that he said would not have been punishable if he had not started by saying that this man was so typical of his race, which means it is aimed not just at that specific caller, but against everybody who belonged to his race. So that is the kind of thing that is targeted. Now, there are plenty of cases in India. And again, I don't have the time to go into all of them. Let me very briefly talk about one or two of those cases. So I remember there was a case, again, more than 10 years ago, which was about a movie called Chand Buj Gaya. And it had to do with the communal riots in Gujarat. I think it was a Hindu boy and a Muslim girl who had been caught up in the communal riots. And the movie had been given, had been sent to the Board of Film Certification for a certificate. And there was a dispute about whether a certificate should be given or not. And the Gujarat High Court, in a writ petition, held that the censor board would be wrong in denying a certificate to this movie, because what the movie did was show something controversial but important, because it is something which talks about communal violence and the effects of communal violence. And in a sense, it portrays social reality. So the court came to the view that this kind of movie should not be banned. So you can see that the court takes a fairly generous approach when it comes to protecting freedom of expression. There was also a case involving the movie, the Da Vinci Code, which became controversial because some Christians took objection to the movie, and it became the subject of I think, a 2-month suspension by the state government of Tamil Nadu. Again, the case went to the High Court, the Madras High Court, and the High Court said that that suspension is wrong, that the state had a duty to protect protect freedom of expression. And if people threatened to go and burn down cinema houses where the movie was being shown, then the state had a duty also to protect the cinema houses from the mobs that threatened to burn down those houses. So you can see that the courts are generally quite willing to protect freedom of expression. And you may be familiar with this other very important case from the Supreme Court of India, which is called Rangarajan versus Jagjivan Ram. This was, again, a slightly old case, 1989, where there was an attempt to ban a movie called Ore Oru Gramatile, which is a Tamil movie, which dealt with the very sensitive issue of reservations. Now, some people said that, this, what the movie tries to say amounts to hate speech. But the Supreme Court said no. And Supreme Court made some very strong observations in favor of freedom of expression. I would ask you to read the judgment of that case if you have not done so. I don't have the time to go deep into this, but it is something worth looking at. Then, of course, similarly, there was a case involving Ramesh Dalal. This was a case that went to the Bombay High Court. It had to do with this very well-known TV serial called Tamas, which dealt with the horrors of partition. And again, somebody tried to block this TV serial from being shown, but the Bombay High Court came down heavily against censorship of that kind and said, no way, this will have to be shown. In fact, the judges said it actually should be made compulsory viewing for young people because it shows reality, even if that reality is uncomfortable. So there are quite a few of those cases. I really don't think I should be able to address them within the time remaining. I only have 5 minutes left, or less than 5 minutes. So let me try to wind up and say that hate speech is difficult to handle, but it is not something that should be handled with one principle, and that is censor the speech that is being alleged as constituting hate speech. The courts will have to very carefully examine the nature of the speech, the words, the context, very, very important, and also whether the people who are threatening violence are to be dealt with in a different way. In other words, the state has a duty to protect law-abiding people when it comes to freedom of expression. Simply because a mob says we are going to take action against someone who doesn't conform to our viewpoints, then that is no reason to ban a book or a movie or any other publication. Now, there are other controversies which have arisen in relation to hate speech of a more general type. So, for example, if you look at historical literature, there is sometimes material that many people today would feel uncomfortable with. So there is a fair bit of racist abuse even in Shakespeare. So Shylock and Othello and things like that. Then there is a question of whether Nazi memorabilia should be allowed to be sold, particularly online. And some countries have banned any sale of such memorabilia. A particularly difficult situation that arises for journalists is during elections. Suppose during elections, a politician goes up on a public platform and makes a hate-filled speech. As I said at the beginning, what should a journalist do? A journalist has a duty to inform the public about such a speech. But at the same time, if a journalist actually uses the same words and they have a genuine tendency to cause violence, he or she would be doing the wrong thing. So in those circumstances, probably a solution would be for the journalist to paraphrase what has been said without using those exact words. Everything depends on the context. And nowadays, you can have hate speech by people who are historically victims of hate. So, for example, what happens if somebody in the Black Lives Matter movement made a hate speech about white people? Don't assume that hate speech is only punishable when it is made against minorities or against certain groups in society. Even majorities can sometimes be the victim of hate speech. So the situation, the entire topic is so complex that, quite frankly, it is very difficult to formulate any single strategy to address it. But I hope I've given you some idea of at least what the challenges are, and also some idea of how it may be possible in the long term to deal with this very intractable issue. I think I'll stop there and again invite your questions and comments. Thank you.
Thank you, sir. So now session is open for question and answer. You may send your question on chat. Sir, we have a question that we have not taken.
Oh, yes.
So Tharun Pranav have raised the question. So should there be a global standard and global enforcement of hate speech?
Yeah. The short answer to that is no, because it is not possible. Not because it is not desirable, simply because it's not possible. Because there are different societies with different approaches to what we loosely call hate speech. And as I mentioned in my lecture, if a society is homogeneous, then the chances of people being affected by hate speech would be slightly less than in a society which is full of divisions. So let me give you a very tangible example of how this operates. Japan, which is one of the world's leading countries, is a fairly homogeneous country. There are very few divisions based on race or religion or ethnicity within Japan. Japan does not have any strong anti-hate speech laws at all. In fact, some people have said that Japan takes a non-regulatory approach to hate speech. Now, it works well in Japan, by and large, although there are criticisms from time to time, particularly when it comes to alleged hate speech against Koreans who live in Japan. But by and large, they've managed to work their way through this problem. The same can be said of a country like the US, where there are quite a few sharp divisions, or India, of course, where there is so much diversity. And so in India, you can have people feeling that they have been unfairly targeted by way of hate speech on grounds of religion, on grounds of language. So you know that there used to be riots in the south of India against the imposition of Hindi, the national language. So when that happens, and of course there's the other problem of caste. Now, in a deeply divided society, you will need laws which are very different from those that you will need, if at all, in a homogeneous society. And quite frankly, the other problem is there cannot be a consensus globally about what should be the content of hate speech. There are different people who have different views, and different countries adopt different approaches. So the answer, as I said, is no, there cannot be a global standard.
Okay, thank you, sir. I'm not finding any question. So I'm asking, may I put question?
Yep.
Yeah. Sir, when I see the hate speech, then there are four perspective I have. I would like to put and I would answer on that.
Yeah.
First, that is a when there is a political agenda is there, and that during election really specifically we observe
Yeah.
that they cross the limit and they put the hate speech. So, what your view on that?
Okay. What you have said is something that is happening not just in India, but in many countries, including a lot of advanced countries, developed countries. Okay. Now, this is one of the things that is to some extent unavoidable in a democracy, because in a democracy, if you want to choose your leaders, then you need to have robust public debates. And that is why people get on platforms and then say some very hateful things. Now, I'm not saying it is correct. The only real solution is for mass education. I keep going back to that point because I think that is important. So mass education means that, first of all, people themselves show restraint when talking. You don't have to make hate-filled speeches to advance your political career, although sometimes it helps. But secondly, the public should show their distaste for such people. So an example would be, in large numbers, people should stop voting for such people. Because remember, in a democracy, as long as you have a fair election, a person who loses an election will have to draw some lessons and he will have to change his ways. So that's one. But the law is also important. So the law should come down heavily in those circumstances where the speech in question has a tendency to cause violence. There is no doubt about that. So if somebody goes on a public platform, a politician before an election, and then says things that amount to inciting the public, saying, go and kill members of this particular community, or go and start attacking them with sticks and stones, that is totally unacceptable. And that is something that the law should deal with. So the law would make it punishable. So there are different ways in which this problem can be tackled.
Sure. Sir, what question is from Rohan Patel?
Yep.
That on what aspects the parameters can be drawn by any court restricting or differentiating free speech from hate speech, particularly against any individual, keeping in mind that some words can hurt one and do no harm to other.
Yep. Okay, it goes back to what I've said in the lecture, and that is, in my view, the dividing line should be violence. So if somebody says something that is likely to cause violence, it should not be allowed. But then the question is, who decides what is likely to cause violence? Because not always is that obvious. Sometimes people can say things in a very subtle or sophisticated way. Then my answer to that will be, it will have to be an enlightened, sensitive, competent judiciary. Ultimately, these are matters which go to the courts. But a lot of the time, action needs to be taken on the ground before a case goes to the court. And there, we are talking about the judgment of police officers, law enforcement authorities. They also should be competent, sensible, sensitive, and most important, incorruptible. Now, one of the big problems in countries like India is that policemen can easily be bribed. So they will definitely not take action or take vindictive action where action should not be taken. And a lot of the time, corruption results in huge damage in such circumstances. So it is again not an easy thing to answer or to tackle, but those are the only ways I can think of. But really, the fundamental point I would make is that only those acts which have a tendency to incite violence or is likely to lead to violence, and I mentioned the clear and present danger test, only those acts should be punished.
Yes, sir. So I have said that about one perspective, that is a political agenda in election. Now, second is that to create a disturbance among that religious groups and the caste,
Yeah.
that ultimately the hate speech were given, and we had observed that in India, that Delhi riots that recently,
Yeah.
that that between two religious groups. So I want that your opinion on that perspective. And second, that to start the agitation and the protest, that we have seen the farmers protest, that hate speech were used. And the third, that fourth of that in specifically our most disturbed area, we can say that Jammu and Kashmir, that to mislead the youth, that hate speech were used. So what's your view on that?
Well, as it happens in all the three examples you've given, education is terribly, terribly important. Why are, for example, you take the last one first.
Yes.
Why are youths getting misled? Because they are not properly educated. If you're properly educated about these things, you will take a perspective which will not make you a hothead. It will not make you react in a knee-jerk fashion. So you will need education. Very, very important. I would say that that is probably the key in the long term, not in the short term, in the long term, to tackle this problem. But in the case of religious groups, quite frankly, there will have to be very strong action taken if it is proved that somebody is doing something, first of all, that is unacceptable in terms of, example, why should a religious leader interfere with something that is not within his domain? That is one important thing. But also, I go back to my original principle of whether what a religious leader says amounts to incitement to violence or not. And sometimes these things are very, very difficult to even ascertain on the ground because there is no hard proof. And when these things happen, there's no guarantee that there's an eyewitness. And sometimes when there is an eyewitness, the eyewitnesses are either terrified or they're intimidated or they are motivated. Now that's the other problem. So for example, when it came to the Delhi riots, there was so much conflict between the viewpoints expressed by different people. So one group would say that I saw the Hindus attacking the Muslims. Another group would say, I saw the Muslims attacking the Hindus. Now, whom do you believe? Because there is no hard proof. In some circumstances, there was hard proof in other circumstances in the Delhi riots. But when this happens, there is a lot of misinformation, and that has to be tackled as well. And don't forget, a lot of the time, unfortunately, even so-called human rights activists create problems because they go there and try to pretend that what they're doing is for the public good. Actually, they are also motivated. They are not motivated always by money. In other words, they may not be corrupt, but what can happen is they may be motivated by ideology or by their bias. You have to tackle that as well. So it's a very complex situation.
Okay, sir.
Have we come to the end of the questions?
Yes, I mean, yeah, but what about that agitation and the protest that now it is become regular to use it as a weapon?
Yeah, well, that will take us to a completely different topic, namely freedom of assembly and association. Okay, on which there is so much to be said. It's a big topic, but very briefly, I'll tell you that freedom of association and assembly, which also includes the freedom to protest, is a fundamental right. And of course, in India, it is a fundamental right under Article under Part 3 of the Constitution, under Article 19. Now, but of course, remember, Article 19 is subject to reasonable restrictions, and then you have to look at Article 19 too. But even internationally, the right to protest is recognized in many of the human rights documents. Now, there the balancing act is again between freedom of assembly, etc., but also against public order on the other side. So you can only protest if you don't cause harm in terms of public order or public disorder, violence, etc. So normally what happens in most free societies, democracies, is for the government to allow protests, but for example, within areas where the public are not affected. So you can go to a big Maidan and you can have your protest. There's no problem at all. But if somebody says, I will only protest in the main street of the city and I will block traffic for 1 month or 2 months or 10 months, that is totally unacceptable because there is a law and order problem. You can't say, I'm doing this as part of my fundamental rights. So there will have to be some curbs placed on freedom of assembly, again, reasonable restrictions. But where you draw the line is not easy. And ultimately, it is a case of sensible people. You know, there are two big issues in all these matters. One is, what is the law? And the other is, how is the law applied? Because the law can sometimes be quite good, but it is applied badly. Equally, the law may not be very good, but it is applied sensibly. Either way, the results are good. But it is terrible if the law is bad and the people who apply it are either corrupt or incompetent or have other motivations. So it is not simple. There are just too many variables in the equation.
Yes, sir. Because protest, yes, right. Because we have a Gandhian thoughts, and that satyagraha is a part of our life. That you can do protest, but during that protest, that hate speech, that speech were given, and that ultimately results maybe into violence or some other issues may arise. So I'm more a bit concerned about that. I'm not that they can means gather and they use their fundamental rights, but that speeches were given during that agitation and that gathering, that is more worried.
Yeah, actually, they can be looked at as two separate matters. One is freedom of assembly, and the other is the hate speech angle. In other words, simply because somebody has been properly given permission to hold a protest rally does not mean that they can do whatever they want at the time of the rally. In other words, they can still be guilty of an offense for what they say without in any way being responsible for assembling. So you need to dissociate the two.
Yes, sir. Now there is no more questions from my side. But everyone is saying about that maybe it is related to speech or not, but everyone say about that mislead the information, and that then USA that they say about that truth were not given, and the world is worried about that whatever is saying that is not correct, and some misleading informations were given. So what's your view on that expressions?
My view is have a multiplicity of sources. So what happens is, if someone presents a biased view, then try to counter it with investigation, research, and get to the truth as much as you can. I mean, it's not always possible to get to the absolute truth, but the last thing you should do is to recommend censorship. So the way to beat false ideas or misleading statements, misinformation, is to get more accurate information. And that means allow a genuine debate, allow a vigorous debate, allow a robust debate. That is the only way you can arrive at the truth.
Thank you very much, sir. I'm very much thankful on behalf of Institute of Law, Nirma University, that you have given your valuable time and discuss the various facets of expressions and specifically freedom of expression. And you have given your depth perspective on the hate speech, and you have answered our questions. I'm thankful to you. Over to Shreya, madam.
Thank you so much, sir. Both the sessions are very, very informative. And we are hoping that once this wave ends and you can come back here and we'll have in-person sessions.
Absolutely. I look forward to that, and good luck with everything you're doing. And again, I'm not finished because I'm going to come back tomorrow and the day after. Okay, so I look forward to seeing you and the students as well. Okay.
Yes.
Sure.
Yes.
So see you
Thank you
tomorrow.
so much, sir.
Sir,
All
thank
the
you,
best.
sir.
Bye bye.
Have a good
Bye.
day. Bye-bye.
Bye,
You too.
sir.